What's going on? I am your host, Dave, 10-year intellectual property attorney dealing with everything. As you can see, the shirts, patents, copyrights, trademarks, and trade secrets. And we got a pretty interesting one for you guys today. Before we get off into it, please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. I would love to have you a part of the IP community where we talk about a number of different things from current events to the Shark Tank breakdowns. I kind of bring on people who have built the business, protect their intellectual property, and we kind of walk through their story. So we have a number of things that we go through on everything intellectual property. And we have a good one today, Fireball. So it seems like it's two liquor companies going back and forth with each other over the term Fireball, which both of them are essentially trying to jockey for position as it relates to a trademark. And the Court of Appeals for the Federal Circuit has put his foot down. Hey, look at this decision is going to be interesting, and it's a lot of learning lessons that I think you guys will be able to take from this one. So this should be interesting. So look at, for all of you who don't know, and I'm not that old, but back in the day it was this candy called Fireball, and it was kind of hit or miss. And I haven't seen it actually, that Fireball candy, around in a long time. But about 10 years ago, you started to see some whiskeys popping up, or whiskey popping up called Fireball. And I actually tasted it, and it wasn't that bad. Not necessarily kind of my drink of choice, but Fireball whiskey kind of popped up on the scene, which obviously you would imagine that the company who was initially selling it has a trademark. So that's Company A. Again, we'll go through the article here, but Company A has a trademark on Fireball. Then it seems like you had another company that comes up at a later point in time, and let's call that Company B. They actually are it's a liquor company as well. And this is a very interesting situation, because I know a lot of times people think that, okay, if you're in the same industry and you try to protect the same name, there's no way that you're going to be successful. But there is a chance for you to be successful. And I think this scenario underscores that point. So you guys definitely want to pay attention, especially if you're looking to try to trademark a term, start a business at some point in the future. So you have Company A that has a whiskey called Fireball, and that term Fireball is protected via a trademark with the United States Patent and Trademark Office. Then you have another company, Company B, that comes along later down the line, maybe a couple years, and they look to trademark the term, I think, Bullshine Fireball. Let me make sure I get the term right, because I definitely want to make sure I'm accurate. And Bullshine Fireball. Now, we already know that the term Fireball is already protected by Company A. So now this Company B is trying to protect the name Bullshine Fireball. And they actually sell the same actual product. It's alcohol beverages. I think Company B is a liquor company. Obviously, Company A is a whiskey company. For me, I may be a novice as it relates to alcohol, but it's all alcohol. It's maybe kind of different types of alcohol, but it's same alcohol nonetheless. So now both of them are fighting over the term Fireball. Company A is saying, hey, Company B is infringing our trademark, and we want to petition for them to cancel the trademark because there's a likelihood of confusion, which you may say is that's a pretty reasonable argument. If you got a trademark for the term Fireball, and the Company B has a mark that they're using called Bullshine Fireball, it's like, okay, it still has my trademark term Fireball in it. So therefore, they're committing trademark infringement in the United States Patent and Trademark Office, and the courts, you guys should cancel their mark. And on Company B's side, they're saying, hey, we have Bullshine Fireball, but this Company A that has the term Fireball trademark, that's not even that's not a trademark term. That's not a distinctive mark. Those of you who don't know, to get a mark that's a trademark, it has to be a distinctive mark. So if it's a generic mark, or in other words, a non-distinctive mark, then you can't get a trademark on that term. So what Company B is saying to the courts and to the USPTO is, hey, this term Fireball that Company A has trademark, you guys should cancel that trademark, because Fireball is not a distinctive term. And it seems like it was some fighting back and forth with Company A and Company B over those matters. Let's pick it up here with this article from Reuters and see what the Court of Appeals has to say on this matter. And I would love to hear you guys' comments in the comment section. So, and again, this is fresh off the press. What's today is March 14th. This came out via Reuters on March 12th, so a couple days ago. So Company A in this case is Cesark. Fireball is valid whiskey trademark, the U.S. Appeals Court of Appeals says. So let's kind of read the article. March 12th, a U.S. Appeals Court on Wednesday affirmed the validity of liquor makers Cesark trademark for its Fireball cinnamon whiskey, rejecting a challenge from Baltimore, Maryland-based distill Bullshine while upholding Bullshine's own Fireball liquor trademark. Okay, this is interesting. Let's continue to get off into it. U.S. Court of Appeals for the Federal Circuit agreed. So the U.S. Court of Appeals, this seems like the district court made a decision. This ultimately got appealed to the U.S. Court of Appeals for the Federal Circuit, which is the Court of Appeals for IP matters. And it seems like the U.S. Court of Appeals for the Federal Circuit agreed with the USPTO that Fireball is a non-generic brand name and that Bullshine's Fireball will not cause consumer confusion with it. So as I talked about earlier, let me bring it back on myself here really quickly. I had talked about earlier that, hey, Bullshine, essentially to be a trademark, you have to have a non-generic distinctive mark. And Company B was trying to say to the Court of Appeals that this Fireball trademark that you awarded Company A, it shouldn't have been awarded because the term Fireball is a generic term. It's not a distinctive term. And the Court of Appeals say, look, man, I disagree with you on that. The term Fireball that Company A has a trademark to, that is a distinctive term, and therefore their trademark is legit. However, on the flip side, Company A is trying to tell the Court of Appeals that, hey, this whole Bullshine Fireball, it's a likelihood of confusion. So people who are buying their Bullshine Fireball, they're going to get confused thinking that they're buying our Fireball cinnamon whiskey, and therefore you should stop Company B from using the term Bullshine Fireball. And Court of Appeals is saying, man, I understand your argument, but Bullshine Fireball is not confusingly similar to Fireball, which is interesting because you would think that, okay, Fireball, they both have the term Fireball in them. They're both liquor. Yeah, just by adding Bullshine Fireball, that still would be a likelihood of confusion. But the Court of Appeals said, no, it's no likelihood of confusion, and Fireball is in and of itself a distinct or non-generic mark. So it seems like Company A won and Company B won in this scenario. So let's continue to read and see what else the Court of Appeals said in this situation. Let's go down here. Spokespeople and attorneys for the companies did not immediately respond to requests for comment on the decision. So it seems like the attorneys are not getting back to the at least this publication. Bullshine applied for a federal Bullshine Fireball trademark in 2015, covering alcoholic beverages except beers. Louisiana-based Cesarac, which is again Company A, opposed Company B's application, arguing Fireball would create confusion with this Fireball whiskey. Bullshine or Company B asked the USPTO to cancel Company A's trademark in response, arguing Fireball was a generic name for a common alcoholic drink containing a spicy flavor and element such as cinnamon or hot sauce to replicate Atomic Fireball candy. Hey, that Atomic Fireball candy, and that was kind of hit or miss back in the day. Like I said, I don't see that candy too much around. Let me know in the comments if you kind of rock with the Fireball candy. All this kind of originated from the Fireball candy. The office's trademark trial and appeal board rejected both Company A's challenge and Company B's challenge. The Federal Circuit affirmed the ruling on Wednesday. The appeal courts agreed that Fireball was a protectable trademark instead of a non-distinctive term for a specific flavor. So they're essentially saying, hey, Company A's trademark on the term Fireball, that's legit. It also upheld the office decision that Fireball and Bullshine Fireball was not similar enough to cause confuse consumers. So in other words, what they're saying is, hey, Company B are looking to trademark Bullshine Fireball, and that's not trademark infringement on Company A's Fireball trademark. So again, both sides really won in this case. And then that's some additional information. So what do you guys think? I think it's some learning lessons here. Even though you have two similar marks, again, the whole standard is confusingly similar, not similar. Even though you have similar marks, which in this case was Fireball and Bullshine Fireball, that even participates or kind of they're in the same kind of field. In this case, or alcoholic beverages. I think if that second mark, which in this case was Bullshine Fireball, if that term Bullshine, I think the fact that it was Bullshine, which is a non or a distinctive mark or a non-generic mark, I think that helped out the Company B or Bullshine Fireball. I think if Bullshine was a generic mark or a non-distinctive mark, I think the USPTO as well as the Federal Circuit would have came down on Company B and said, hey, that's a likelihood of confusion. But I think that based on the word Bullshine of Bullshine Fireball, because obviously you can't protect Fireball, Company B can't, because Company A already had a trademark on it. But the fact that Bullshine was a non-generic or distinctive mark, then I think that helped out that helped out company B tremendously in this case, which again, I think that's the learning lesson. So to the extent that you're trying to come into a particular area that somebody else has a trademark in, you're trying to kind of maybe use the same name in your mark, and that name is, like I said, there's a trademark on that name. If that word or words that you are adding to that previously trademark name, it better be a distinctive or non-generic word, or else you may be on the lookout or maybe on the hook for trademark infringement. I thought this was a surprise. I could have seen the court coming up on the other side of things saying, hey, company A already has the term Fireball trademark. Company B, yeah, you have Bullshine to it, but you still are using Fireball. So Bullshine Fireball, again, I think if it was a generic, if they would have said that Bullshine was a generic mark, I think company B would have been in trouble. And to be honest with you, like I said, I could have still seen how if the court would have said Bullshine Fireball, it's still a likelihood of confusion with the trademark term Fireball that's owned by company A. So, I mean, all in all, if you're going to use a name that's already trademarked and you're just adding a word or two to it, you better make sure that those additional words are distinctive or not generic. Because to the extent that they are, you're probably going to be on the hook for trademark infringement. However, at least in this court, what this case is showing is that to the extent that that additional word, which is in this case was Bullshine, is a distinctive, then I think you have at least a chance of overcoming being on the hook for trademark infringement. So let me know what you guys think in the comment section. Hey, let me know when the last time you had the Fireball whiskey. Like I said, that's not my thing. I probably had that 10 plus years ago. And yeah, just kind of not something I was able to get down with. But I mean, it was cool to try nonetheless. But let me know if that's your drink of choice. Let me know if you like the Fireball candy. Like I said, I haven't seen that in decades. But back in the day, to be honest with you, I never rocked that candy. It was way more of the candies that I thought were good outside of the Fireball candy. So not kind of a staple for me growing up. But again, if it was for you, let me know in the comment section. Hopefully you guys enjoyed this one. This one actually was a sneaky valuable it was a valuable video or some value add, just because I think it illustrated some points to the extent that you're trying to get a term trademark that's using a term that's already trademarked out there, being able to put yourself in a better position to overcome being on the hook for trademark infringement. I think this case was a good illustration of that. So again, let me know if you guys enjoyed it. Please hit a like button if you did enjoy it, but also hit the subscribe button to be a part of the IP community. We're doing a lot of great things over here. We're going to continue to grow the IP community, coming out with some great things. So you'll definitely want to get a part of things, get down with the movement now as opposed to later. So hopefully you guys enjoyed this one. I'll see you on the next one. Take care. Peace.